John Banks almost certainly suffered from paranoid schizophrenia, but in the mid-19th century, our understanding of that disorder had barely progressed beyond primitive biblical ideas like demonic possession. Banks hallucinated evil spirits and believed he was being pursued and harassed by the wonderfully named Featherstone Alexander, who had actually died some years before. In 1841, Banks was confined to an asylum but was later released. By the 1860s, he was still periodically having delusions, but was managing his own affairs. He had rental income from several properties and was dealing with the agent for those properties and looking after his own money. Banks had made a will in 1838, leaving everything to his sister. She had since died, and her daughter Margaret Goodfellow had come to live with Banks. He had a great deal of affection for her, and in late 1863 he made a new will with his niece Margaret as sole beneficiary. He had no spouse or other children. Banks then died in 1865. Margaret had still not reached adulthood, which back then was aged 21. She died in 1867, still underage. The plaintiff in this case was the son of John Banks's half-brother. He was Banks's next of kin and heir if the 1863 will was invalid. The defendant was Margaret Goodfellow's half-brother. If the 1863 will was valid, then the estate passed to Margaret and then on to her half-brother. So was the will valid, given that it was made by somebody who clearly suffered from psychotic delusions, but who may well have been entirely lucid at the time the will was made? At trial, a jury found that he was lucid and the will was valid. On appeal, Chief Justice Coburn said, "No doubt when delusions exist which have no foundation in reality and spring only from a diseased and morbid condition of the mind, to that extent the mind must necessarily be taken to be unsound. But the question still remains whether such partial unsoundness of the mind, if it leaves the affections, the moral sense, and general power of understanding affected, should have the effect of taking away the testamentary capacity." The court answered, no. If a person still had those affections, moral senses, and understandings necessary to consider their testamentary intentions, then a latent unsoundness of mind would not remove their right to make a will.